get here we go. It looks like we're ready to go. So we will reconvene this Constitution Day session of the Kansas Court of Appeals. I think earlier we've introduced the panel, but I'll go ahead and do it again in case anyone else is joining us now online. My name is David Bruns. I've been on the Kansas Court of Appeals since 2011. Before that, I was a Shawnee County District Court judge for many years, it seems like. I'm joined today and privileged to have two of my colleagues, Judge Sarah Warner, who has celebrated recently her first anniversary on our court. It's a pleasure to have her on our court. Before that, she practiced law in Lawrence, Kansas. And it's also great to have with us on the panel Senior Judge James Burgess, who's been with us since about 2014 as a senior judge after he retired for being a judge of the Sedgwick County District Court for many years. So it's great to be on this panel, and we appreciate counsel. Just for those who may be viewing, this is an interlocutory appeal by a priest and the Archdiocese of Kansas City, Kansas, following the Wyandotte County District Court's denial of their summary judgment motions in this case involving allegations of sexual abuse. Just so counsel's aware, I think you are, prior to today, we have read your briefs. We've read the decision of the district court. We've reviewed pre-hearing memos prepared by our research attorneys. So we're pretty familiar with the facts now. I know because there's just some statute of limitations questions, you probably will need to argue some of those facts, but you can probably cut to the chase and go to the issues and only discuss the facts as necessary. However, it's your time, and you can use it how you want. We have granted additional time, so each side gets 20 minutes. And I know that at least for the purposes of this appeal, that Mr. Bloomberg and Mr. Stewart are aligned. As appellants, have you made any decision on how you two want to divide your time?
Yes, Judge. We were going to reserve 3 minutes for rebuttal. We'll share that. I think we were talking about a 2-and-1 split. And on the primary argument, we will share that too. I'll try to give a cue to Mr. Stewart about, there's about 3 minutes left, so he has time. I think that we've decided I will be doing the primary arguing today.
Okay, man, this is like a math project here. So 3 minutes, that's 17. So you're going to take about 12 minutes, 13, something like that, and then turn it over. Okay.
Yes, Judge. Fine. If I get a warning or a heads up, that'd be great.
Well, I'll do my best, and I'll be somewhat lenient. You don't have to use extra time, but if you go a little long, we will allow you to do that. And the same goes, we'll make sure that Ms. Randall gets an appropriate amount of time as well. So we won't be too strict on it, but if anybody starts to go way over, then I will call you on it. But if not, we're ready to proceed. So Mr. Bloomberg, are you going to start?
Yes, Your Honor. May it please the court. I was listening to the prior argument, and prior counsel said if we're not going to enforce the statute of limitations, then what's the point of having them? That's kind of the primary point of our argument today. We have 3 independent arguments that concern the statute of repose and the statute of limitations. And the first is, and all 3 are independent. So for plaintiff's case to survive appeal, in our opinion, the plaintiff must prevail on all 3. And the first is the 8-year statute of repose, 60-515. The second is second core issue. It applies to the Archdiocese, but not to MJ. And that is whether the exception in 60-523 applies to a non-perpetrator, organization, or employer. And then the third point is if 6523 applies to both defendants, is plaintiff's claim nonetheless time barred based on his own testimony? So I think the parties are in agreement about how the statute of repose operates. A claim doesn't have to accrue. It can't be told. Concepts like repressed memory don't affect the statute of repose. But what it comes down to is, as Your Honor said, it's a little bit of a math puzzle. Not quite a 2 + 2 = 4 argument, but maybe a July 1st, 1992 -8 argument. So the point that the plaintiff is trying to reach is to survive the statute of repose, he has to establish that the abuse continued beyond July 1st, 1984, which is 8 years before 523 was enacted on July 1st, 1992. And our position under the statute of repose is that the case should be over because plaintiff is bound by his pleaded facts that the abuse ended in 1983. So I think a little bit of history and background is warranted here. So before the lawsuit was ever filed, plaintiff called the Archdiocese and he said these core facts, which are in the summary judgment record, plaintiff put them there. But he told the Archdiocese that the abuse took place for 3 years. He said it occurred from 4th through 6th grade, so 4th, 5th, 6th. He said it happened while the then priest was at St. Matthew's Parish. And he knew those dates because that's when the movie Gandhi came out in 1982. So the diocese made a record of that call. That is an admission. That would be admissible in evidence as an admission. But then we skip forward to when he files his lawsuit. And on August 31st, 2017, plaintiff filed a lawsuit. And he pleaded exactly what he told the diocese. The abuse happened at St. Matthew's Parish, a 3-year period, and it was approximately 12, until he was approximately 12. But there's no approximately in this phrase. He says between his 4th and 7th grade years. Words like between and until have meaning, but when he says between 4th and 7th grade, that's the same thing as what he said to the diocese before he filed the suit, that is happening from 4th through 6th grade. Again, a 3-year period that ended right about the time he started 7th grade. But then we add the uncontroverted facts from the records. Plaintiffs don't controvert this fact, that MJ was last assigned to the parish in 1983. June of 83, he left. So all those facts are in a line, consistent with what plaintiff told in his pre-suit admission, consistent with what he pled, that this all ended before 1983. Add 8 years to that, he never gets to July 1st, 1992. And
let me ask you a question here. As I was going through this, you deposed him about this, is that correct?
Yes, we did, Your Honor.
And what, if anything, did he testify about whether or not this priest allegedly abused him after he was transferred from St. Matthew's to wherever, I can't remember, Kansas City, I believe?
Well, he ultimately started changing his testimony. And the abuse suddenly was no longer in 1983. It was at a funeral in 1985 or 1986. It was in a place called Paxico, Kansas, just outside of Topeka. And so the abuse was no longer about being at St. Matthew's, it was instead ongoing abuse that occurred after he left St. Matthew's, which was inconsistent with the petition and inconsistent with his other admissions. How we got there, Judge, is during the motion to dismiss hearing, plaintiff argued and said this is a knife's edge case, right on the edge of the statute of repose. We know that. And the trial court, I think had the best intentions. I thought, well, if we can establish what the last date of abuse, when MJ left the parish, we would know when the last date of abuse was. And so that's why we took his deposition. That's why we had limited discovery. And we produced the records showed he left in 83. And suddenly it was no longer a knife's edge case. It was, well, that ends it. That should have ended it based on those facts. And now plaintiff then argues, no, it was 84, 85. And on appeal, plaintiff is now saying it happened until the junior year of high school. So we're well beyond the petition. And that's where our primary point of error here is that the trial court should have never allowed plaintiff to contradict his petition. And Kansas cases hold that an attorney is stopped from taking a position contrary to the petition. And so this is a lot like the Mays versus Ciba-Geigy case. We didn't cite it in our brief, but I found it afterwards. A 1984-85 case from Kansas Supreme Court. And there what happened, the defendant moved for summary judgment based on the plaintiff's testimony. And after that motion proceeded, plaintiff opposed his own testimony, tried to contradict his own testimony with an affidavit saying, nope, I was wrong. Those weren't my facts. That's not my testimony. Came up with new facts. And the Supreme Court said, we will not allow a sham affidavit to contradict prior testimony and then force upon the defendants the burden of trial. And that's—
Counsel, remind me, was the petition that was filed in this case verified?
No, Your Honor, it was not. And it doesn't need to be verified. I think when the plaintiff submits it, any act filed by the attorney is imputed to the client. These are his statements. And Kansas law is clear that a factual statement in a pleading is binding against that party.
But we also have notice pleading in Kansas too, right? I mean, you don't have to put everything that's necessary for your claim in a petition. You just try to state a valid claim. Are you saying that the problem here is that there wasn't an amended petition in light of these additional remembrances or alleged remembrances, or what's the problem?
Well, you're absolutely correct, Judge. This is a notice pleading state, and in fact, Kansas is a very liberal notice pleading state. We have not adopted in Kansas yet the Twombly or Iqbal standards that the federal courts have used. So there's no need to put these facts in the petition at our complaint. Plaintiff chose to do that. Case law also holds that when you have a judicial admission, and if you plead a fact, it's a judicial admission. You do have an opportunity for typos, mistakes, to amend that. We're now 3 years after the petition, and plaintiff has never amended those facts. And I've got a summary here of all the times we've argued this. We've argued this 4 different times about, are you going to amend the petition? Is there a mistake? In April of 2018, my opponent said, probably the petition should be amended. Then April 18th, again, well, the pleading should be amended. There's a lot of things in here. I found some typos. I found the wrong name. Did not say the dates were wrong. And then in June of 2019, plaintiff takes the opposite position. It says a petition can be amended at any time, but this particular petition does not need to be amended because there are no judicial admissions concerning the ages. Well, there were judicial admissions concerning the date ranges and the grades of when this happened. So I don't think there's a problem with the petition. The petition is what it is. It's never been changed. It's binding. If plaintiff had moved to amend the petition, which plaintiff never did, we would have had a different argument. That argument would have been, you have a claiming a mistake here. You're not claiming that this was an error. You're trying to change the facts, and the Kansas courts say you can't do that. You're stuck with the facts unless you promptly identify a fact or error that you made a mistake.
On that one, let's take a step aside and let's put this in the context of just a kind of run-of-the-mill traffic accident.
Sure.
Okay. And if there was a petition that was filed and it said that the defendant was traveling at 45 miles per hour when the defendant hit the plaintiff in the case, and then later on during the course of discovery, find out that the defendant was traveling at 60 miles per hour. Does that mean that the plaintiff has to go back and amend the petition, or is the plaintiff stopped from saying that the defendant was traveling at 60 miles per hour, even though we find out that that's what the fact was?
Well, I think the problem is how plaintiff frames the issue. If you're uncertain about your memory, about how fast you were going, about the dates of the abuse, you use Kansas notice pleading to your advantage. He could have simply pleaded, I was abused as a minor. I'm not sure of the dates, and that would have been sufficient to state a claim. The plaintiff chose not to do that. Plaintiff decided to use very specific facts. In our view, only he knows this. MJ has denied the abuse. The Archdiocese had no knowledge or notice about this abuse. So whatever he's saying, that's for him to say. He's the one who controls, is the master of his petition that decided what it would state and what the facts were. He also had 35, 37 years to come up with the facts he would put in that complaint. He claims to have remembered the abuse and have been bombarded with his memories in 2014. He's had since then to craft a petition. He had called the Archdiocese in 2015 based on our records. And again, those facts are exactly what he said in the petitions. There's no allegation of mistake here. And I think it would be a huge injustice if we would allow leave to amend after 3 years of litigation, after a full appeal now, based on some perceived mistake that plaintiff could have corrected any of the number of times plaintiff was arguing about potentially amending the petition. So I think it would be that there were opportunities to correct a mistake, but those opportunities have long passed. And there's really no allegation there is a mistake.
So basically, you're arguing the petition is basically admission against interest that's binding at the summary judgment stage. Is that accurate?
And both the motion to dismiss, so we had a motion to dismiss first, and then we also filed a motion for judgment on the pleadings and motion for summary judgment. but primarily the facts are controlled by the petition.
I'm looking at the petition, and I noticed that in paragraph 7, it uses some what I'll call weasel words. From the time plaintiff was approximately 9 years old until he was approximately 12 years old, Father MJ sexually abused him. That isn't, I mean, approximately leaves some leeway, doesn't it?
It sure does, Your Honor. And I think that term has to be read in conjunction with the other allegation, that this abuse occurred between 4th and 7th grade. And when you put those two together, you have a pretty definitive time frame of when the abuse happened.
And do we know, as an uncontroverted fact, when he entered 7th grade?
It's uncontroverted when he entered his grades. It's uncontroverted when his birth.
So when did he enter 7th grade?
He entered 7th grade. We put a chart in our brief. Apparently didn't copy well when we filed it. He entered 7th grade in September of 1983. He ended in 1984.
Okay, so he entered 7th grade prior to July 1st, 1984.
Correct, Judge. So
does that, just for my recollection, does that allegation in the petition say that it before 7th grade or between?
Well, that's my
7th and 7th grade.
I can clarify this. So if we hold,
what paragraph are we referring to? I've got
I believe it's 7 and 9 of the complaint. So the first allegation is that the abuse occurs until approximately 12. Well, if that means it's the date he turned 12, the abuse ends in April 1983. If you use the word until in its normal meaning. If the court concludes that between his 4th and 7th grade years means the conduct stopped before the start of 7th grade, then it's barred before September 1983. I'm sorry, that's when the last act was. If we generously conclude that until approximately 12 means not until, but instead means throughout age 12, the last act was in April 1984 when he turned 13. If we generously conclude that between 4th and 7th grade actually means both after 6th grade and throughout 7th grade, the last act was in May 1984 and the claim is still timely.
Or perhaps August 1984?
In August 1984 would have been one, impossible because MJ had left the parish and plaintiff said the abuse only happened while he was at St. Matthew's. It would have also been when plaintiff was 13 in an 8th grade or just before the start of 8th grade. And that's not what he has pleaded. And also I want to make it clear that under the rules.
Wait a second, I asked you a question earlier and I thought I got a different answer.
I'm sorry, Judge.
Let me clarify that. Is there someplace in the record where he testified or that says the father only abused me, and it doesn't need to be these exact words, but the father only abused me while he was a priest at St. Matthew's in Topeka, Kansas?
He doesn't have to testify to that, Judge.
I didn't ask if he had to. I asked you, did he testify?
No, because the story has started changing by then.
Okay, so he has, because you just said there that he said, at least I understood what you just said is that, because if he had said that, we're done. But it sounds like he didn't say that.
No, because he
started adding more to it. And the question is
right,
whether or not the district court could allow him, and the problem on amended pleadings is technically, I used to teach pretrial discovery for years at Washburn Law School. Technically, you could amend your pleadings all the way up until submission to the jury, but usually it's done finally at the pretrial conference when a pretrial order is entered, and that becomes the binding document that controls the course of the. I mean, I recognize, because I've cited it myself, you can't just use a self-serving affidavit to defeat summary judgment, but it's somewhat of a dilemma here when you're talking about something that somebody's trying to remember that happened years ago. I recognize you've got some great credibility arguments here, but that's not what we're to decide.
No, I don't think it is a credibility argument, because when you have a fact that has not been changed for 3 years, it's conclusive. It is an unequivocal concession of the truth. It can't be controverted, and it's binding. And if there was some argument 3 years ago that this was wrong or needed to be changed, then an amended petition, plaintiff should have filed a motion for leave. That never happened. Here we are in appeal.
But it isn't part of this, the evolution of this young man's memory over time. And I don't see, I'm not aware, and you can correct me if I'm wrong, anywhere where you have contested this evolution of memory, where he began remembering more and more and more.
Well, and Judge Burgess, I think that is exactly why we have a statute of limitations and statute of repose. A plaintiff should not get to rely on an organizational superior record keeping and then make it up as he goes along. Because otherwise what can happen is I just saw this record. I remembered this date. Oh, I just saw this record. No, it was a different date. And what happens is this is an opportunity that opens the door for spurious claims that for many of these instances, the witnesses are gone. We may have a document that reminds plaintiff of some event. He can latch on to that. But we have a hard time refuting it because the witness is gone, the custodian is gone, we may not have complete records, and we're left with a victim who allegedly really hides behind the shield of evolving memories. I couldn't remember. This has been very traumatic, and I get that, but at the same time, this has to be fair to both sides.
Isn't that perhaps a very compelling, but a compelling credibility argument, not an argument regarding what information has to be pleaded and then how discovery will be limited as the case moves forward?
Well, I would be cautious of using a credibility argument to absolutely end-run statute of limitations and statute of repose. These facts, these pleadings, these admissions have to mean something. And if we let folks just continually evolve their claims based on what they're remembering over a course of almost 40 years, there is no statute of limitations. They'll all be.
But in these cases, isn't repressed memory a fairly common occurrence?
Well, I would argue that repressed memory, one, is junk science. It doesn't exist. But repressed memory is not part of this case. The plaintiff has argued in the brief that and pled that the plaintiff had repressed memory. We asked about him in his deposition. You ever been diagnosed with repressed memory? No. Has anyone ever told you had repressed memory? No. You ever researched repressed memory? No. You ever talked to anybody about repressed memory? No. He doesn't have repressed memory. So I know that's in the brief and plaintiff argues that, but we asked him that, put that in the brief for that exact reason. This is not a repressed memory case.
Counsel, before we
Mr. Stewart probably wants a shot in here sometime, but
yeah,
go ahead.
Before we use up too much of your time, I do want to ask a little bit about this statutory interpretation question or position. Could you explain to me the difference between based on and as a result of?
Well, as a result of, according to Black's Law Dictionary, means the same thing as cause. And there are numerous cases out there that say that if you have an action that is based on sexual assault, that action then encompasses negligence claims and the underlying battery claim. But here we have a statute that says the action must be a result of what's in childhood sexual abuse, which is defined as a sex crime. A result of means caused. So the statute here reads that the action must be caused by a sex crime. It's a specialized battery section. So an action for a battery is typically 1 year. An action for damages caused by a sex crime, according to this statute, is 3 years from 18 or 3 years from reasonably discovery. But there are numerous states that have held that you can have a based on arising from standard. Kansas didn't do that. And in the neighboring statute of limitations for healthcare providers, contracts, Kansas adopts those rules. It says any action based on contract or any action arising from the failure to render or rendering of healthcare. But we didn't use that language here. And the reason we didn't, the legislature didn't, is because one, it is against a narrow exception to a general statute of repose, but there's also very good reasons why you would limit this only to the perpetrator. That's because the organization, the employer, the group is always one step removed. We'll never know exactly what happened between two individuals. We won't have the same knowledge they do. Sometimes this could be a fleeting volunteer, a coach, a substitute teacher, who knows? And the perpetrator and the victim will always know better than what the organization will know. So I think Kansas has made the legislative decision to only apply this statute to perpetrators. And the language that's used in our statute is very similar to what Missouri uses. Missouri uses the word cause, but Kentucky, Rhode Island, South Dakota use the same as a result of. Those statutes are almost all identical, that the action must be caused by or as a result of a sex crime. And in those situations, the courts have all held they're limited only to the perpetrator. And even in states that have used the based on language, Colorado is one, South Dakota is one, and California, I think, used to be one before they changed their language. But even in those cases that say an action based on the sex crime have held that because sex crime is defined in termination with criminal statutes, it still is a perpetrator-only statute. This is
But
not.
this doesn't define it as a sex crime. It says no action for recovery of damages suffered
Correct.
as a result of childhood sexual abuse. So it strikes me that here we're not just saying caused by a sex crime. It's any action for damages suffered as a result of. And so don't we read that broadly? I mean, if the legislator wanted us to read it differently, couldn't they have indicated that within the statutory language?
Well, let me tell you why that doesn't work, Your Honor, because the statute of limitations are based on particular claims and counts and action. If that logic were to apply in any action, let's assume a bouncer and a bar employer, and the action for damages is going to be from the bouncer hitting an employee. That's battery, right? The action and the damages there are the battery. That's a 1-year statute. You get 1 year to bring the battery claim. I could not argue as a defendant, this is an action for damages for battery. Therefore, the longer statute of limitations for negligence is irrelevant because this is totally a battery action. That's what plaintiff is trying to do here. Take a very specific battery section and then argue it applies to all negligence, other intentional torts, fraud, conspiracy, whatever the other 10 counts are in the petition. It's not how it works. This is it must be narrowly construed because it's a narrow exception to a general statute of repose. Where otherwise, the 1-year battery statute would knock out every single claim that's ever asserted in connection with a battery action because the damages are connected to the battery. Again, here we're saying if you've got an action for damages caused by a sex crime, very narrow reading, this is your statute of limitations and is an exception to the statute of repose. That's exactly what the other 4 states have almost virtually identical statutes to Kansas have held. So I know I've gone over time and I'm sorry.
Okay, any other questions at this point from the panel? Because if not, we have went over wise, but you were responding to questions and we'll be fair to everybody. Mr. Stewart, I'll give you 5 minutes if you needed to supplement or add to these arguments.
Thank you, Judge.
To answer any of these questions that you've heard.
Ross Stewart on behalf of Appellant MJ, Judge. And one of the questions I heard earlier from the panel was whether or not was it stated anywhere that this abuse only occurred while my client MJ was a priest at St. Matthew's. And in the record, volume 1, page 19, which is the petition, paragraph 4 states at all times material, defendant father MJ was a priest at St. Matthew's Parish. And the purpose of us opening up this limited discovery after the motion to dismiss hearing was because we were looking at whether or not, based on what was pled, this abuse would have ended in 83 if my client was no longer a priest at this church.
Right, because we would be done, assuming that it's uncontroverted that he left at a certain date in 1983 and any abuse occurred while he was a priest at St. Matthew's in Topeka, Kansas. We're done. Then we don't have to worry about all these flexible floating dates that are going around. The dates at that point are irrelevant. It's whether or not when he left and whether that's controverted or not. So you're saying that there is in the record, and I've got the petition. So paragraph, would you say 4?
Yes, Judge.
At all times material, defendant Father MJ was a priest at St. Matthew's Parish in Topeka, Kansas. And he is sued herein individually and in his capacity as priest at St. Matthew's Parish. Was that cited in the as an uncontroverted fact in the motion for summary judgment?
So we have records that show that Father MJ left that parish.
No, but wait a second. I recognize that. I'm asking about in your summary judgment motion, did you put that as an uncontroverted fact?
Yes, Judge.
That at all times, okay. And did they controvert that at all times material defendant Father MJ was a priest at St. Matthew?
Judge, I don't believe that they did. I believe that the phrasing of this was Father MJ left this parish by 1983. And I believe that statement is uncontroverted. We have records that show. There's
not a statement that says that all the allegations occurred while he was a priest at St. Matthew's?
I don't believe that we have that in the statement of fact, Judge. I'll double check.
So we're back to what the petition claimed, and okay. I understand your argument. It would have been nice if the summary judgment motion would have had a uncontroverted fact, and then if they didn't controvert it, it's done. But I guess that's why we're here. So
yes, Judge.
Go ahead.
I'm double checking this right now because I don't want to mislead the court on this. Let's see. Yes, Judge, just about the timing of him leaving that. So, but ultimately, we're also looking at whether or not, in terms of utilizing Rule 141, are the controverted facts the plaintiff is using in their response to it actually creating a dispute as to the facts, because some of these facts that are cited are not cited with any sort of evidence that is attached to it as is required by Rule 141. And then there also was an issue on, I'm representing the former priest in an individual capacity who is no longer part of the diocese. The diocese has their own counsel. I'm representing the other party in the suit as a defendant. We both filed very similar motions for summary judgment with our own statements of facts that are separate statements of facts. In essence, substantively, they're very close to being similar, but they're not enumerated the same. The statement of the facts do not use the same evidence for each statement. In responding to this, there was only one statement of fact response from plaintiff, and then also there was one memorandum in opposition filed by plaintiff. Now, in terms of a procedural, it wasn't answered correctly pursuant to Rule 141, which requires that you must respond to that statement of fact. And so one of the questions that was up to the district court was, was this properly answered? And should all of the statements of facts from my client be admitted as uncontroverted? And if they are, then that would prove that my client was not there, and therefore this abuse did not occur, alleged abuse did not occur past a certain standpoint. And so we're also here looking at whether or not, in terms of 141, are all of the facts of my client admitted or not? And that's something that I believe is an error on the district court's part, that if my client's facts are admitted, my client needs to be, granted summary judgment.
Okay, we'll certainly look into that issue as well. We're familiar with Rule 141, and it is supposed to be strictly complied with. You're almost to your 5 minutes. What else would you like to add, if anything?
Judge, I don't really have anything further. The only other points I was going to touch on, I believe Counsel Blomberg already did, in terms of judicial admissions in the petition. And I understand that it could be amended, but as he had stated, we've been dealing with this case for almost 3 years now. There have been no movements to amend this. And at this point, I believe we're set out for jury trial in March of 2022.
And when was when was the plaintiff's deposition taken?
Let me see, Judge. I believe that was 2018?
But what I'm trying to get at is how much time was there between his deposition and when this summary judgment motion was decided?
I'm not sure, Judge.
Okay. Well, I mean, it's probably in the record.
Yeah.
But at no point was a motion to amend ever filed, is your point?
No, Judge. There hasn't been one put on file. We discussed it at least 4 times in separate hearings, and nothing's been on this matter yet.
Any other questions from panel at this point? If not, Ms. Randalls, we're almost caught back up, but I'll be flexible if you need a little additional time, especially if we pepper you with a lot of questions, so that you may proceed.
Thank you, Your Honor. I won't belabor the facts since you have already read over most of what had happened, but I would make it known that MJ is a known predator and had been stripped of his faculties as a priest prior to HB ever making a report. So this interlocutory appeal is for guidance on the question of whether 6623 applies to the Archdiocese. And we contend very strongly that the text of the statute makes clear that the cause of action for childhood sexual abuse creates liability not only for the individual perpetrator, but also the enabling archdiocesan defendant. Now, the defendant's briefing and the argument, we believe, are rife with misunderstandings regarding both the facts and law. First, the facts that the defendant points to are misleading. The deposition testimony was very clear with regard to several issues. And the first issue that it was very clear regarding is the plaintiff fully repressed all memory that he had been abused by Father MJ. Plaintiff testified on page 63 of his deposition. I mentioned previously that there were a lot of cases that were going on, and it brought back all of the childhood memories from when I was abused. And it was like it was happening right then and there, memories that I never had before. Defendant
counsel, I want to, these are such sad facts, but what I want to focus on right now is your petition and those facts that were alleged in your petition. do we allow a plaintiff to impeach his own petition by way of after the fact deposition testimony?
Well, Your Honor, the short answer to that is yes. That's not what happened in this case, but Kansas law is fairly clear that the petition is merely the starting point and that there is a reason for discovery. The petition is not the end all and be all for the purposes of a case. As you mentioned earlier, if you have an individual who puts in the petition that he believes that an individual was traveling at 45 miles an hour when the car hit him, but subsequently expert testimony reveals that it was actually 60 miles an hour, we don't exclude that fact merely because the plaintiff believed at the time that he'd filed the petition that he was going 45 miles an hour. Now, in this case, because
what about in this petition? So if we look at the facts in this petition, the facts that are set forth in the petition don't get us to July 1st, 1984.
But actually they do, Your Honor, because we always have to use squish words in petitions like this because repression of memory is one of those situations where you do have ongoing revelations as an individual is triggered by more and more events. And so we specifically put squish words in the deposition for that very purpose. So we put in there that it was approximately between 4th and 7th grade, that it was approximately between 9 and 12. And in fact, it occurred through the summer of his 7th grade year. So when we say it was during if you look at the petition, it says between his 4th and 7th grade years. It doesn't say that during his school, that the 9 months that he was there, it says between his 4th and 7th grade years. And he testified that by the time he had 8th grade, he started in sports. And so the sexual abuse diminished in 8th grade. That's where we came up with the 7th grade year, but it still occurred during the summer. And plaintiff then when we received the documents from the defendant, it showed that some of the things that he thought had occurred during that time frame, based upon the documents produced by the defendant, they actually occurred a little bit later than he thought that they had occurred. For example, he testified that he was sexually abused at Paxico and at Meridian, Kansas. Well, when we got the documents from the Archdiocese, we found out that his travels to Paxico and Meridian actually occurred in 1985 and 86. Our plaintiff had mistakenly thought that they were in 1984, but no, they were.
Testify, let me on that. Did he testify about those that was he thought that was when the priest was still at St. Matthew's, or did he testify that now he remembers stuff that occurred after he left St. Matthew's?
Well, that's kind of a mixed question, and the reason that's a mixed question is because even after he was transferred, Father MJ still was at St. Matthew's a lot of times. And he was there, for example, in 8th grade when plaintiff got in trouble for drinking wine. And it was MJ that came in to discipline him for the drinking of wine, even though according to the documents that the 10 pages of documents that the diocese produced, he was already at the Kansas City diocese. But just because he was physically placed there, he even testified that Father MJ even testified that he didn't have a regular place at the rectory. And so he was provided with temporary housing. It doesn't specify where that housing was that was temporary. Nonetheless, it was clear, and plaintiff testified clearly, that he was at St. Matthew's even during his 8th grade year, because he was the one who came down and disciplined him when he got in trouble for drinking the host and the wine that's associated with communion. And so he didn't have any actual, when they asked him, when did he leave? He said, I don't know when he left. But I do know that he was there in my 8th grade year because he was the priest who was involved in disciplining for the drinking of the wine. And he was there for rallies. He was there for ball games. He was there in the rectory at times. And he took the plaintiff to various places. So the plaintiff's memory.
Procedurally speaking, let's say that we agree with you. And if that were the case, then who makes this finding? Does it, as to when the abuse, the alleged abuse ended? Is it a jury finding that is submitted on a special question? So does this have to go to a jury trial? Is it something that there can be an evidentiary hearing before the district court, and the court can decide that particular date question? I'm just trying to figure out what does this mean procedurally?
Well, Kansas law is very clear that if the facts are uncontroverted with regard to a statute of limitations question, that it becomes a judge-tried issue. But if the facts are in dispute as to the statute of limitations, then it does go to the jury. In this case, the facts are absolutely in dispute. Now, with regard to the petition itself, like I say, we made the petition so that there was squish room, knowing that the plaintiff could very likely continue to have memory recall as events unfolded, or as even as Chad said, as documents became available that impacted that, because that happens all the time in discovery. If someone—
Counsel, I recognize that, and I brought that up to counsel's attention in paragraph 7. But in paragraph 4, there are no weasel, squish, whatever words you want to call it. It says, quote, "At all times material, defendant Father MJ was a priest at St. Matthew's Parish in Topeka, Kansas, and he is sued herein individually and in his capacity as a priest at St. Matthew's Parish, period," close quote. I don't read any weasel words into that. It sounds like at all times that he allegedly did these things, he was a priest at St. Matthew's. And now it seems like you're trying to add something after he was a priest at St. Matthew's. And that does seem to be inconsistent with the language in the petition.
Well, the squish word there is "at," because it doesn't say he was employed by St. Mary's. It says he was physically at St. Mary's. And he was physically at St. Mary's even after 1983. St.
Matthew.
That's St. Matthew's, sorry. He was physically at St. Matthew's even after that. And our client testified that he was physically present at St. Matthew's during his 8th grade year, for example.
Well, that would be a great argument, other than you go on to say in the same sentence, in his capacity as a priest at St. Matthew's Parish. I mean, that sounds like as a priest at St. Matthew's, not just there as a fan to watch a parochial league basketball game or something. I mean, that seems pretty specific.
Well, and at the time that the petition was written, we had believed that he had been transferred in 1985. And so that's why the petition was written that way.
So why not amend the petition? I mean, you had a lot of time here. Why not amend the petition?
I
know the hindsight's 20/20, but did you make some strategic decision to not amend this petition?
Yes, the strategic decision was we hadn't gotten all of the rulings on both the summary judgment and the motion to dismiss claims that would guide us with regard to what the court was thinking with regard to the other causes of action. And so since I was going to wait and amend everything all at the same time once we had all of the issues determined. So probably I should have amended the facts prior, but as Judge Burgess pointed out, we do have the option to amend the petition at any time, and we can amend the petition in conformance with the discovery and the facts that come forward. And the facts that have come forward were slightly different than what we had in the petition, but that doesn't mean that there's anything in the petition that doesn't set forth a cause of action. And that's the issue. Well,
some of the facts are slightly different. Some are slightly different, but some of these allegations are when he's 15 years old now.
Well,
I mean, it's hard to say that 15 years old is approximately 12 years old. I can give you, 13 or something, but 15, he's probably in high school. It's a whole different. Did he go to St. Matthew's School, or did he just go to the parish?
He went to St. Matthew's School.
Okay, so he would have been probably out of St. Matthew's School by that time.
Right. And that's where we got into our client always, and he testified that the abuse occurred through the summer and into his 8th grade year when he was at St. Matthew's. But then when we received the documents from the diocese, he also testified that he was taken to Paxico and Meridian and the abuse occurred there. His recollection is that he was taken to Paxico and Meridian before he left his 8th grade year. But when we received the documents from the diocese, the diocesan documents show that Paxico and Meridian were at a later date than that. So there's going to be a question of fact that we have to evaluate through the course of discovery was, when did Father MJ go to Paxico and Meridian? According to our plaintiff, it was 8th grade and prior. According to the defendant's documents, it was after 8th grade. So that's where we come up with those dates. It's specifically based on the very limited discovery that was produced by the defendants.
Counsel, I want to talk a little bit about this statutory interpretation question that I was discussing with your opposing counsel. And, you know, ordinarily, we do say, you know, when you have a cause of action for something like battery, you know, it has to be against the actual individual who commits the battery. Why is it different in your view here?
Well, this is a remedial statute that was specifically designed by the legislature to give a cause of action to those who've been abused by childhood sexual abuse, recognizing that there are significant issues and bars to bringing those kinds of complaints. And so this is a remedial statute. It is not an exception to 515. When you have a remedial statute, then you interpret it broadly. But even if you weren't interpreting it broadly, you do have to look at the exact words of the statute itself. And the statute itself establishes that this statute is directed to the harms that were directed to the plaintiff by the virtue of sexual abuse, any cause of action arising out of sexual abuse. Failing to supervise is a cause of action that arises out of sexual abuse. What's more, if you look at the text of the statute, you'll see that there are, in every statute, in every paragraph of that statute, and virtually every sentence, it iterates that this is an injury or harm-based statute. It starts off in the very first sentence saying that as a result of childhood sexual abuse, any harm as a result of childhood sexual abuse, any action as a result of childhood sexual abuse can be brought under the statute. That includes the failure to supervise, because an enabling defendant is still liable for the actions that have occurred. Corporations have been subject to criminal statutes since at least 1910 in Kansas.
Counsel, I want to take a look at Section B2 of 60-523, which defines childhood sexual abuse.
Yes.
So within that definition, I'm going through and I'm looking at all of these, looks like 8 to 10 different crimes that are included within the definition of childhood sexual abuse. I'm not seeing a negligent failure to supervise included in there.
Well, it's not specifically included in the definition of what childhood sex abuse is. That's definitional with regard to the types of acts that that create childhood sex abuse. But corporations have been held responsible for the acts that are found within that. For example, aggravated indecent solicitation, solicitation of a child, sexual exploitation of a child. All of those are things that a corporation as well as an individual can be held responsible for. And Kansas has been doing that since at least 1910.
And are there in those instances, are those damages that are suffered as a result of the abusive act, or are those damages that are suffered as a result of the negligent supervision or hiring or disciplining of, say, an employee?
Well, they're all causal. And what I mean by that is that the failing to supervise or even intentionally placing a priest or a child in the harm's way of a priest causes these kinds of harm as well. And so the injury or illness that arises from the sexual abuse would never have occurred had it not been for the failure to supervise, had it not been for the intentional failure to supervise, had it not been for the aiding and abetting of the priest, or whatever cause of action occurs or fits within that particular client's case. So they are one and the same. They're all causative. If there was no failure to supervise, then there would be no childhood sex abuse.
And I understand that, and I have such, my heart goes out to people who have suffered these kinds of abuses. But I'm looking at the legislature's decision in 60-523. And I'm trying to figure out, because it's our job just to enforce that policy choice that the legislature has made. And so I'm just trying to ascertain what that policy choice was here. And it's hard to look at that list of acts and think that that was not an intentional limiting of the statute.
Well, I think you have to go back to A, where it says no action for recovery of damages suffered as a result of childhood sexual abuse. So it's saying you look at these things. Did these things occur? Yes. Then you say no action for recovery of damages suffered shall be commenced. And so you have to go back to that. And the damages suffered includes all damages. And that is also contextually shown by C, where it goes down and it talks in the last sentence about discovery of the last act by the same perpetrator, which is a part of a common scheme or plan of sexual abuse. A common scheme or plan indicates that there has to be some form of aiding and abetting or colluding for the sexual abuse. So I think that part of the statute also indicates that this is directed not just to the person who physically does the sexual abuse, but also to those who collude, aid, abet, or otherwise ratify the sexual abuse. And then if you look at the squish language that's found in that section itself, it goes on to say, or any prior laws of this state of similar effect at the time the act was committed. And the word effect is important in this one because the definition of effect is not just that it's the same statute, but has been overturned at some point or repealed. Rather, it is a statute that carries the same kind of gravity. And the aiding and abetting statutes, those kinds of things, these are inchoate offenses that are also included within the offense that's established. So you can be held responsible for aiding and abetting, for those kinds of things, accessory before and after the fact, even under the statutes that are alleged. And those the aiders and abettors don't have to be a corporeal defendant. They can be a corporation or a corporation defendant, and they can be the ones who were the enabling defendants. So I think when you look at all of the structure of the statute, that it is clear that it's aimed at the harm that was created, not at the actions of the individual. And that when you look at the whole of the statute, it's also directed toward the aiding and abetting, the enabling defendant, the defendant that failed to supervise. Did that answer your question, or do you have?
No, I think I understand your position. I wish that the legislature would have been clearer in its choice, or perhaps the legislature was clear in its choice, right? But one way or another, it does not lend itself to a clear answer.
I understand that concern. All of the other states that have looked at this have determined that the words are important. And so if it's looking at the harms arising from childhood sexual abuse, it includes all actions that include childhood sexual abuse. Also, the criminal statutes, where there's a lack of verbiage, you also look at the lack of verbiage. It doesn't specifically exclude enabling defendants, and it's a broadly remedial statute. All of the cases that have looked at this so far, and particularly the BSA case out of Connecticut, walk through the way in which the statutory interpretation. And what they have found is that the absence of verbiage showing that corporations are not responsible indicates that they are responsible, that you don't exclude the non-corporeal defendant or the enabling defendant just because the words don't include them specifically in a broad remedial statute. I'm not sure that made sense, but the BSA case makes it very clear that when you're looking at the absence of words, like we have in this statute, that the absence of words actually means that you don't exclude a particular class of defendant.
You're a little bit over your 20 minutes now, but I'll give you some more time and so you can wrap up and make sure that you've answered any questions the panel might have.
The last thing that I would talk about is the question that Judge Warner asked earlier, and that is the question of arising out of and result of. Is there any definitional difference between the two? There's a California case actually that looked at that specific issue and found that there's no difference because both mean that there has a causal connection to. And that case is the Pension Trust Fund versus Federal Insurance Company, found at 307 Fed 3rd 944. It defines arising out of as having a causal connection to, which is in the same as a Kansas case, Estate of Graber versus Dillon. And so because we have the very same words, it doesn't matter whether you use arising out of or as a result of, both of them refer to the exact same thing. And so using statutory construction, it makes no difference whether or not you use those terms. So you can't say that because Kansas did not use the word arising out of, it does not include enabling defendants. The California cases, as well as the Graber case, establish that that is exactly the opposite.
Any questions from the panel that haven't been asked? Okay, thank you, Ms. Randalls. Mr. Bloomberg or Mr. Stewart? Or
Yes,
like
Your Honor.
a tag team wrestling match here.
Yes, I'm tagged in. First, one issue with the California case my opponent just raised is that California changed its law at some point, and it expressly made its statute apply to entities that were the legal cause of sexual abuse. So that I haven't had a chance to read that case, but California did change its law. Kansas has not. Second, my opponent has argued that 60-523 is a remedial statute. Remedial statutes are statutes that provide a remedy, typically, or a right that didn't exist under common law. The Wrongful Death Act is a remedial statute, and Mechanics Lien Act is a remedial statute. This is not a remedial statute. It is not defining or granting any rights that didn't already exist. It is instead defining how those rights need to be asserted. And it defines as a statute of limitations and an exception to the statute of repose when an action can be commenced. It doesn't give any new rights. It's therefore not a remedial statute. It is not viewed liberally. Instead, it is construed narrowly. Third, the concept that this statute includes organizational or corporate liability, I think is an erroneous concept. And the reason is that Kansas, since 1910, we heard, has had statutes for corporate liability. The legislature was obviously aware of those statutes. It didn't include them. And more importantly, in subsection B2, it makes it clear that the act must be committed against the person. The Archdiocese can never commit an act against a person. As we explained in our brief, commit means to perpetrate, to cause a crime or harm. Again, this is a purely perpetrator statute. Some of the arguments too about the facts of whether he was at St. Matthew's and visiting. When a priest is assigned to a parish, that is a very important matter. Ms. Randalls knows this. She's litigated several church cases over the years. Under church law, when a priest is a parish priest, that means something. When he's visiting or he comes back to attend a basketball game or a funeral or help with a mass, he's not the priest of that parish. He's visiting. Ms. Randall was very specific, and the plaintiff is very specific in the petition that the abuse happened while he was a priest at St. Matthew's. And so I can't remember exactly what we put in the facts right now, but that's the purpose of pleadings. They're supposed to define the issues. So we know how to frame our arguments. So we know how to raise affirmative defenses. So we know what discovery to conduct. And we relied on these facts in establishing the motions that we filed to date. The last point we didn't get to address is our third independent argument about even if 60-523 applies, Kansas would still bar this claim. And that's because plaintiff testified that in 2014, he's in Guam and he's starting to hear about the abuse. He's hearing about it in the news, and the radio. He can't go anywhere where he's not hearing about it. And then in the summer, that summer of 14, he's bombarded. And then after some reflection, he decides to call the Archdiocese, according to his testimony, in September of 14. Because this is an exception to the statute of limitations, it's plaintiff's burden to prove the exception, not ours. The burden of the exception always falls on the plaintiff in this situation to toll a statute of limitations. So when you say summer, that can mean June, July, any of the 31 days of August. The plaintiff filed his petition on August 31st, 2014, after he had already said and knew he was a victim because he'd been bombarded by the memories of the abuse. So that's all I had. I'll defer the rest of my time to Mr. Stewart.
Thank you.
Mr. Stewart, take us home.
The court had a question earlier about whether or not the plaintiff in this matter had stated specifically that these trips to Paxico or other places, alleged trips with my client, where he was based out of. And in the deposition that was taken of plaintiff, which is, I believe, on the record, volume 1, page 270, and it's on page 131 of the deposition itself, on lines, let's see, 10 through 13, it says, and I accompanied him to his outreach churches on numerous occasions in Paxico and Meriden, and I know that he was based out of St. Matthews, which coincides with the petition. So he has stated during his deposition that my client was based out of St. Matthews. He stated in the deposition and the petition that fact. I don't believe that fact is controverted, that my client left St. Matthews in 1983, which would still provide us relief from the statute of repose under 6515. So I just want to make sure that the court was made aware of that, because I know there was a question about that earlier. And then lastly, we had some conversation about alternative and hypothetical pleadings and why we haven't had this amended yet. And there's, the plaintiff has always permitted a liberal interpretation of its petition and all the facts that are there. But like the court had mentioned, 15 is a bit of a stretch. So a liberal construction and interpretation of that petition can be allowed, but the petitioner is still bound by that petition within the reasonable bounds of it. And then lastly, if there are separate arguments being made or separate facts being brought up, it's been shown, let's see, in the state of Dykeman case, where there are contradictory or inconsistent allegations in the pleading, the conflict is going to be resolved against the pleader. So even if all of these facts are being brought up into this matter, and we're stating, well, there are other facts that are being brought in, we're arguing under 141, they haven't had enough evidence to actually be controverted, or haven't applied through 141 correctly, or however the argument is that we're getting to them not being allowable and that we should be given summary judgment on remand. Ultimately, those dates are still in conflict to the pleader, and that the plaintiff's dates should be 1983, my client left St. Matthews. It was alleged that that abuse was while he was at St. Matthews in his capacity as a priest, and therefore we should be granted summary judgment. And so that's all that I have, judges.
Well, thank you all. Good arguments. We try to get our decisions out within 60 days of oral argument. This one could take a little bit longer because there's some complex issues, especially on the statutory interpretation. But we'll do our best to get it out as quickly as possible so that you will know at least the result from this court as soon as we can get to it. So thank you all. Good arguments. And I would ask that the judges would stay on just a second, and I'll ask everybody else to go ahead and excuse themselves. We are adjourned.
Thank you, judges.
Thank you, Judge.